I can tell you, folks, that after every trial, I go in and I speak to the jurors. And though many of them were reluctant or certainly not happy about having jury duty, after they have heard the trial and deliberated and reached a verdict, every single jury, there's been several people who not only tell me that it was an interesting experience, but that it was also a rewarding experience.
That's the judge in Karen Reed's second murder trial for the death of her police officer boyfriend, which began on Tuesday. So far, only 10 of 16 jurors have been seated. Jury selection is expected to be crucial as her first high-profile trial ended with jurors deadlocked and no verdict. Let's bring in Randy Zelin, a criminal defense attorney and former New York City prosecutor. Randy, this is an interesting case, and I just have to share this. This is a petition to the Supreme Court by Karen Reed's lawyers. I'm going to read part of it, and it's an interesting argument. And sometimes in cases like this, much to the chagrin of those of us who watch from the outside, your job as a defense attorney is to make an argument. Here's what it says in part, quote, here, beginning the day after petitioner's first trial ended in a mistrial, 4 jurors contacted trial counsel to inform them that the jury had reached a final and unanimous but unannounced conclusion that petitioner Karen Reed is not guilty of murder in the second degree and leaving the scene of the collision. 2 of the 3 charges pending against her. In sum, the defense learned post-trial that the jury reached a verdict that was not announced. A novel argument. What say you?
Well, it is not so much a novel argument as it is whose responsibility was it to find out before a mistrial was declared whether or not the jury had reached what we call a partial verdict? Massachusetts law is really unclear on it because Massachusetts law talks about how the judge may, and I think that's the operative word, and I'm looking at my notes here, the jury may, with the consent of the judge, return a partial verdict, or, if required by the judge, return a partial verdict. So the question is, was it incumbent upon the defense to say, hey, judge, can you inquire of this jury and see if they've reached a partial verdict? Or was it incumbent on the judge from the get-go to say, ladies and gentlemen, at any time, if you've reached a partial verdict, let me know? Now,
wouldn't that, I'm just curious, might that have been in the, apparently not in the jury instructions? So if I'm a criminal defense attorney, I would imagine that it would be my responsibility to ask. Is that a bridge too far?
Well, here is the difficulty in all of this. A trial really is not a search for the truth. A trial is really not about justice. A trial is about winning. The prosecution wants to win, get a conviction. The defense wants to win, get an acquittal. So as a defense attorney, do you want to say to the judge, please find out if there's a partial verdict? Because in most cases, a partial verdict is they've reached a verdict of guilty on one charge, but they're not done with the rest. So maybe what you want to do as a defense attorney is let them keep going, let them keep going. Maybe they'll change their mind. So it is so difficult with the, well, it's easy with the benefit of hindsight to say, yes, of course, the defense should have inquired. But in that moment, when you've got to make the decision real time, as a defense attorney, you probably want to keep your mouth shut. Here's an instance where you guessed wrong.
Well, let me ask you, though, from the, if you're a justice and you're looking at this, I think the argument would be, at least for me, in the absence of a very clear admonition or instruction, I just don't know that the defense has a leg to stand on here because there is no direct instruction for the judge to have done this. Am I overstating that, or is that part of the dance for the 9 justices?
Well, I think, unfortunately for me, I now have to reverse course and say, well, if a trial is about justice and a trial is about doing the right thing, if 12 jurors, in fact, came back unanimously in that room and said, she is not guilty, then why in God's name wouldn't we want to look into that more? If we're anything about the presumption of innocence and if we are anything about the rule of law, Well, if the rule of law is if all the jurors come back unanimously and say not guilty, then the defendant is not guilty, then it seems to me the judge really should go back. And I've had this happen to me in a trial in real life where there was an issue while the jurors were deliberating. And the judge said, no, just wait. Let's see. And I'm like, no, I don't want to wait. Judge declares a mistrial. And we found that after the fact that the jury was completely tainted. I got a new trial. There, the judge conducted a full investigation, interviewed each juror. It seems to me the trial judge should have interviewed each juror. And if all 12 of them said, yes, she is not guilty, she is not guilty, then it seems to me this case should be gone on those counts if we truly believe in this notion of not guilty means not guilty.
Yeah, but of course, there's a bit of hearsay there. They're saying post-trial they were contacted. I think there's a lot of room, wiggle room here for dispute. But I love this conversation. Randy, let's have you back. It should make for a very interesting week and months ahead. Randy Zelin, thank you so much for your time today, my friend. Appreciate that.
Hey everyone, I'm Emily Campagno. Catch me and my co-hosts Harris Faulkner and Kaylee McEnany on Outnumbered every weekday at 12 p.m. Eastern, or set your DVR. Also, don't forget to subscribe to the Fox News YouTube page for daily highlights.